Well, good evening, everyone. Tonight we're going to talk about move-aways and final orders. So jump on here before you go out tonight for Friday night, and let's get a few things resolved so you can let your mind rest. How many of you thought if you moved closer to the other parent, you could see your kids more? We're going to be talking about that. Did you move closer and your ex moved again? Right? So tonight is court and move-aways. So jump on here and we will get started. All right. So first thing, when it comes to move-aways, we're going to talk to you about people who don't have final orders first, and then we'll get into modifications, right? So before you get a final order and you're going through the process, the first thing you want to do is make sure that you know, and this is kind of in our way, that you know your state statute, right? You want to know what it says. So you kind of work backwards. Those of you that know me know that I like to work backwards, right? Because that's what you can expect when, if there's a problem later down the road, that's what they're going to refer to. Hey, Joe. Hi, Clutch. Thanks for joining me. So look up the statute before you get a final, all right? Most of you just go to attorneys and you ask them to help you stop your ex from moving, or you don't even think about that when you're going through it the first time. So we want to get you to think about that. For those of you who don't have an order in place already, let's address you first. When you're getting final orders, make sure this issue is addressed in your order. It's a current issue. Here's why. If your issue comes up later, you don't have to necessarily head into litigation, which is expensive, costs you most times more than the original litigation does. But also, you can get things in there that protects you if that person moves away and not have the expense of more litigation to have this happen. Okay? So your orders are supposed to be the guide, and they're supposed to be preventing necessity for future litigation, right? So you need to address as much as possible. An example I can give you is we dealt with a father once. He was in Chicago, and Social Security issues came up due to retirement, and the issue was kind of addressed in the order and addressed in some of the conversations during the trial, and so they saw that as he had an opportunity to address all of the issues that would arise regarding Social Security. So when he went to Social Security hearing, they tried to defer him back to family court, but also what happened is the result wasn't what he wanted, and he was having a difficult time getting Social Security to give him the result that he wanted. So it made him have to reuse family court, and that's not where you want to be. So that, you might say, is the job of your attorney to tell you, but like you all know, you have to take responsibility for your case, just like you take responsibility for your health. So that's why we're helping you see the things that you might not know about now. Okay, so this is why your order needs to be more complete in the move away area, because we see this used a lot by parents who want to prevent you from exercising the time that you do get in a final order. So they make it hard for you or impossible for you to actually get the benefit of what you fought for in that order. And the most frequent way we see that happening is by moving away. All right, so make sure your wording is very specific, and so you can, well, I'm here, someone's saying something, okay, you guys can hear me okay, right? Just say yes or no if you can hear me, Joe or Clutch. Okay, well, I'm going to presume you can hear me. If you can't, put something there. Okay. I don't see. Okay, good. All right, thanks. I thought someone was trying to tell me they couldn't hear. All right. So in the move away, before we get into any kind of wording, I just want you guys to understand that you can bring this issue up even if it's not an issue that's being litigated, okay? So if your attorneys tell you you can, don't buy that. Go look at some other final orders. The way that they normally address it in the wording of final orders is they will usually put some sort of geographic restriction. It doesn't thoroughly address moveaways, does it? What it'll do is it will say something like the parent, or it'll say the geographic restriction area for your case is a certain boundary. So it might say you can't move out of a county area or a school district, right? But then it doesn't say anything after that. So how many of you have orders like that where you have a geographic restriction but it didn't actually prevent a move away, and when the move away happens you're now having to litigate because there was nothing else addressed in the order, so there was no guidance for either of you in it, and now you're defaulting to the statutes that are in place, which is a whole new trial, right? Okay. Your orders also usually say things about particular possession times, don't they? It tells you, like, if you live within 100 miles, you'll get this kind of possession time. And if you live outside a 100-mile radius, you might get a different kind of possession time. Do any of you guys have orders that say if you move closer that you get equal time? I have seen orders like that, but that's not exactly what we're talking about tonight. Okay, but what I'm saying is possession parenting time orders are super specific, but your geographic orders aren't necessarily very specific. So what gets overlooked is putting the next step in that restricted geographic part of the order, putting the movement clause in there, as we call it, so that you have a complete possession clause, right? So do you guys have the geographic restrictions now, or are you aware of those? So put yes or no in there. Does your statute address it? Those are things you need to know. So now that you know that you need a move away clause, and if you don't have one in a final order and you're in a modification, you can do this as well. But now that you know that you need one, now you have to decide what you want it to say. How do you want it to address a move away? So one example that I have is you could put that if the other parent moves away, then the custody stays with the parent who remains in the geographic restricted area, right? And the reason I brought this up tonight is because I actually have seen an order like that, and the parent didn't even realize what they had in that order. And as soon as the other parent moved and didn't come back to the area, they went to a lawyer, and the lawyer filed for modification. And we try to avoid as much as possible getting into modifications for you if you have other things that you can address to get the outcome you want, because modifications reopen that judge's broad discretion. So your goal is to keep things as limited as possible so the courts can't run up these ridiculous bills on you, and so attorneys don't want to automatically default to let's start all over, let's do all these studies and get all these court-appointed experts. So we're trying to help you avoid that, and the best way to do that is to limit the issues that the court is going to address. And I'll tell you how you limit on the other side too as we get going. So how many of you have considered something like that? If you haven't considered a move away clause, you really need to seriously think about that. The other thing is, if you put this in there, then you don't have to go to court to flip custody, do you? Right? And so that's another fallacy that a lot of parents think. They're like, well, the other parent won't give the child to me, so now I gotta go back to court to get custody. So make sure the language is enforceable, just like the language in your possession time is, or your parenting time. So your order shall have language in there that says shall do this. They are ordered to do this. Don't leave it up to, if this happens, then this is what's expected. Or don't leave it to wording like, then this changes, right? If it just says it changes, if custody just changes, you might have some trouble enforcing it. So check with the lawyer on that. By the way, I'm Sherry Palmer with Fixed Family Courts. If you don't know, I'm not an attorney. I don't practice law, and we are not a substitute for an attorney. We raise issues that we get, that we experience, whether it was ourselves or with other parents, that we feel is necessary for you to know so that you can get better results and outcomes so that justice can be done, right? Things that you aren't necessarily being told or might not be thinking about. So now that you know what geographic restrictions are and where you can put a move away clause, did you know that juries in some states, like in Texas, for instance, are restricted to only ruling on who is going to be the primary residential parent and a geographic restriction? That doesn't necessarily mean that they can't rule on whether or not you get to put this move away in there as part of your geographic restriction. However, I wouldn't necessarily recommend that's what you put into a jury charge. I would leave that with a judge rather than trying to convince 9 or 12 people to stick that in there. Okay, so just because you have a jury trial doesn't mean that you also don't have the judge ruling on things, because they are going to rule on how much time you give that child. And some parents actually bifurcate, like they split the trials into 2 different trials. That's super expensive. I don't know that you have to do that, but check with a lawyer on it. So if you're entitled to a jury and you're trying to get them to rule on certain things, just be aware that you probably want to keep the legal aspects and the particular things that you're trying to get enforceable language around with the judge, not the jury. So let's see if any of you guys have those kinds of orders before we go on to modification stuff. Okay. So I'm presuming most of you are in modification right now that are watching at this moment. Have any of you thought about doing this, or are any of you dealing with move away stuff right now? And if so, kind of tell us in the comment section how you're addressing that. So here's the other reason that you want a move away clause in there. Okay, let's say that you do move closer to that other parent, which we've had parents do, and then the parent keeps moving because they want to frustrate your relationship with that child. That gets super expensive. That's very disruptive for the children. Some of you may want to run and get a modification saying, hey, look, they're moving the kid too much. That hasn't been super productive, and they just run up costs on you and make you broke. So that's the other reason. This is something you really want to consider. If one of the parents wants to move temporarily, there are also things that you can put in your order regarding making agreements with that parent, right? You can put specifics around what is required for that agreement to be valid. So in the state of Texas, you might want to require a Rule 11 and state that it has to be in writing, signed by both parties, and put into your file. And the reason I say that is because if you just make casual agreements in these situations, when you run into a problem, you are going to inevitably run into more problems, because the law is going to say certain things and they are going to apply that whenever they can. So if there's something general and you didn't get more specific with it in your order, then they're going to apply the general law. That's going to cost you a lot of money to get into court and have to prove things. So again, your final order is your guide. Okay, you don't want to chase people all over the state and country. You don't want to have to chase a ton of evidence trying to prove that you didn't exactly agree to what they said you agreed to, right? So make that clause in your order as well. The other thing you may want to do in your final order is make sure that it says that if one clause is found to be invalid or void, it doesn't cancel out the whole rest of your order. So back to what I saw with attorneys, they don't always read all the language in your order if they think you're just going to follow their advice or their status quo, their pattern of just filing for a modification. So you might actually have something in your orders now that helps you prevent going through modification, like enforcement. We talk to people about that all the time. And this is a form of enforcement, everyone. If you have a move away clause and the other parent is moved and they won't come back, or you're not able to get your child from them, that would be an enforcement contempt issue. You don't need to open up the modification process, okay? So let's back up to why we're talking about this. We are talking about this so that you can prevent opening yourself up to more litigation later down the road. So it doesn't help you resolve getting out of the courts if you're heading towards your very first final order. What it does is help you prevent having to go back to court for every single issue later. So if your order says that you have addressed the move away and you give temporary permission for the other parent to move, then the other parent, if they decide not to come back, you then invoke your final order, right? You invoke that, fine, you don't have to come back, but I'm now primary parent in this, so the child comes to live with me, and hopefully the other thing that you've addressed is that the possession orders then flip to the other parent, or make sure you address what the parenting plan will look like. Will they get the same parenting plan you're on now? Because that'll be something they'll try to argue they need to go in and litigate over if it's not addressed. But there is a way to make sure you still prevent a modification from happening, right? Because they're going to try to go in and say, change circumstances, I moved, they agreed, the final order doesn't address everything. So you have to know how to shut each one of those down, don't you? So you want to argue that there were no changed circumstances, and if something wasn't addressed like that about what kind of parenting plan they have, then you just argue there needs to be a clarification, not a modification. That's going to protect all of you. So I hope this helps. I want to make sure that you understood this. So tell me yes or no that you're understanding. You want a move away clause. You want to make sure that before you head into a modification, you read your final order, because it might have one. You want to put in there that if the other parent moves away, that primary custody flips to you if, we forgot this part, if you continue to reside within that geographic restricted area. If you move to, then none of this applies. And I bet you some of you have seen orders, if you have finals already, that say if you move out of the geographic restricted area, even if the primary parent still lives there, they're no longer restricted to that geographic area. That's how I see most of the geographic restrictions written. This was the first time I've actually seen one written as if one parent moves and one stays in the area, that custody flips. Okay, it's brilliant. I love it. You guys really need to consider that and present that to your lawyer. It is your job to give them creative solutions, because they're so busy taking on tons of cases so that they can make a living. They may not be in their creative mind, right? They may just have routines that they use, and you're not getting the benefit of all of these other options. This is why you come to our channel, to get more information, right? So again, if you have an order, make sure you read it. Make sure your attorney is aware of any language that protects you from a modification. All right? Because it was heartbreaking to me to watch this parent find out from us that they had gold in there, and now they've got to unravel a bunch of other things that have happened. Because once you file for a modification, now the other side could respond and counterfile. So they've got to backpedal. They've got to undo a bunch of things. And so here's for you guys who are in modification. So let's say that you didn't have this, or you didn't know, and you're in modification. So let's start with you don't have this in your order. So if you don't have it in your order and you're in a modification and there really are changed circumstances, then consider putting it in. Again, even if it's not an issue, check with your lawyer and say, look, I want more protection so I don't have to keep ending up here in the courts. So ask them to put that in your pleadings, that's one of the things you're asking to modify in your final order, that you want this move away clause addressed. How you address it is going to be up to all of you, because all of your circumstances will be unique and different. So the one that I saw basically said that if one parent moves out of the school district restricted area and one parent remained, it didn't matter if it was the non-custodial parent or not, that parent custody then would go to that parent. Physical custody would then go to that parent. So if that's what you want done and you plan to remain in that geographically restricted area, then you will benefit from that, won't you? Save a ton of money. Some people have told me just recently they've spent over $175,000, and some are having to do reunification counseling and regular counseling. I think it's costing them like $300 a week to do these things. Not something you want to get into, and it wasn't something that they had any choice over. The court is forcing it. The court is ordering that, because when you guys go back to modify, they see this now as a high conflict, especially after you had an agreed order and maybe you were able to afford going bankrupt the first time. Now, when you come back, they're going to see this as, all right, we have opportunity now to take your money like we didn't get to the first time. I know there are lots of good people, good family law attorneys who mean well in this, and I apologize if you take offense to that, but really, bottom line, that's what it ends up being, because no parent should be having to spend this much money to protect their rights with their children, and they absolutely should not be subjected to any other court-appointed expert, or whatever you want to call them, guardian ad litem and amicus, judging them on their choices that they've made. We call those matters of conscience. That's not even legal to pass judgment on your matter of conscience. Your beliefs, your values can never be wrong. And they're not allowed to judge you on them. There's case law on it. Look it up. But yet they do it every day and use best interest as the excuse. So make sure that your geographic restricted area is clear. Make sure that you address when custody flips, because this was not in their final order. Hi Richard, I'm Sherry Palmer with Fixed Family Courts. That's fixedfamilycourts.com. If you want a membership so you can get more information on this topic, just put /membership in there. Thanks for asking. So if you are running into the fact that you've already filed for a modification and you find that you had something in there that protected you, then what you want to do is figure out, did the other party counterfile? If the other party counterfiled, then you've got to decide if you withdraw your pleadings, because this is what we've done several times with different parents. And usually it's with parents where there is no counterfile, right? The other side did not counterfile. Just a response to your pleadings is not a counterfiling. It's completely different. If you don't know the difference and you can't afford an attorney, at least pay an hour for them to explain some of these concepts to you. You can get into our membership site, and we do define concepts according to how we integrate them constitutionally. So we will give you some basics there, but we're not lawyers. So the reason you need to go to the lawyer, even if you know the definition, is because case law further interprets defined terms, and case law specific to your state, not just federal stuff. So the way they'll actually use it is very many times not intuitive at all. Okay, a lot of parents ran into that problem when they tried to use a federal removal statute where on its face looked like, oh my gosh, we found a silver bullet. It says, if our constitutional civil rights are being violated and we can't be heard on them in the states, we just remove it to federal court and we can be heard there under this statute. And they found that it had been defined to limit who could use it, and they went by the purpose that it was originally passed, and et cetera, so they got into all those details. And again, another heartbreaking situation. Lots of parents still try it because that's part of their movement. That's what they're promoting because that's their protest. But if you're using something as a protest, know that you're using it as a protest. What we're talking about tonight isn't so much a protest, it's using the system and the process the way it is now, because we know it's not fair, we know it's not just. So you got to use every gold nugget you have in this, right? So let's say they didn't counterfile, they only responded. You can withdraw your filings and you can file for enforcement if they're not going to comply with your order. Make sure before you do that enforcement, though, you have followed what's required for enforcement. So in other words, in most states, you actually have to try and get your child, and if the other parent is going to hold you to being a non-custodian, but your order says you are now the custodian because they moved out of the geographically restricted area, then you need to document that, whether it be with police reports, individual witnesses, however you need to do it, video, phone calls, text messages, our family wizard, however you need to document that you attempted to exercise your rights according to your order. That's what you need to do, right? I've never seen any state hold the other person in contempt for a parent who didn't go through all the steps to try and get their kid. Okay, and if they come and take the child, that happens. That doesn't mean you can't enforce, right? Okay, so somebody says our family wizard is great. I agree, but there are also some free ones on there. So one thing I don't like is orders that require parents. US Route 66 West. Ignore that map. That's our map. I'm in my mobile office, so we drive commercial loads so that we can travel around the country and meet some of you. We're actually headed to Chicago, so if any of you are going to be in Chicago, we'll probably be there late Sunday night. But if you'd like to come out and meet us, I will just send me an email, send me a message, a private message. You can find me on Facebook and let me know, and we can possibly meet up at one of the truck stops. A lot of them have Denny's and other meeting rooms there, or restaurants with back rooms, and we can work on some of these details. That's the reason we travel all over the country. So where were we? So the enforcement. So you've got to go through all of the enforcement steps. And we have more information on that in our membership sites as well. We're developing new courses so that it's more step by step. We have a lot of foundational stuff in there, and now we're putting step-by-step stuff so that you guys can more easily follow it according to what you're dealing with. And I'm starting to break it down into topics too, so you can go in and search a topic. It's not completely there yet. It's still like massive videos of foundational lectures in there, which, by the way, have helped so many parents, hundreds of parents over the course of the years. It might even be at 1,000. I don't know. I haven't counted, and not everybody tells me who uses our stuff. Some people come and say they got better results. They were more confident. Oh, thanks, Robert. So Robert uses Talking Parents. That's the one I was trying to think of. That one's free. I think they have a paid version too, don't they, Robert? But the basics are free, right? And it's very, very similar to our family wizard. And that protects a lot of people because it has a calendar, schedules all the communications, and judges are able to access that communication. It saves you a lot of time and money. You don't have to print all that out separately as evidence. That's my understanding. Now, I don't know how that complies with due process, because then you're not proving up your evidence. So anyways, up to you how you guys want to use that. So back to enforcement. Let's say you did all the enforcement steps you needed to do, and now you still cannot get your child. Would you go and file for modification in that case? I hope every single one of you said no. Okay? If you didn't, you need to go back to the beginning of this video and watch it. You don't file for modification. You file for contempt of the order. You file for enforcement, and you stand by those provisions in your order, because you know what, you guys? You already fought for that. You already paid for that. Don't pay twice. That's why I'm here tonight. Don't pay twice. Remind yourself about that. No matter how much an attorney tries to talk you into it, no matter how much they say how many more things you can litigate and get out of it, because if you're enforcing and you're doing contempt, you don't get to put in some extra clauses, right? So you don't get to go and put in a move away clause if you don't have it. Enforcement and contempt is for what you already have written down in the order already. Okay, so the other way that this helps you is you can now block the other parent. Oh, darn it, Robert. He says he just left Chicago. Okay, if the other parent files for modification, let's say you withdrew it because you just found this video and you figured it out. If they file, now you can argue there are no changed circumstances. Now they have the burden to prove that, don't they? So you can ask to have their motions dismissed, or their petition. But let's say they counterfile, and you decide you're going to withdraw your motions. Well, you can still argue they have no changed circumstances and their pleadings need to be dismissed. The risk that you take now is now you don't have any responsive pleadings, and if it goes to trial just based on their pleadings, now you're only on the defensive. Not responsive pleadings, I'm sorry. You don't have any primary pleadings of your own. You haven't counterfiled. So the only thing that you would have is responses. So, and that could put you on the defensive. You need to evaluate your strategy. If you haven't seen my mind mapping coursework, you should probably do that so that you can use our analysis that we do and figure out what strategy you should apply by putting in all the facts and issues of your case. We do provide that service. We can't do everyone though. That's why we offer the courses, because a lot of parents, we do have to say, you know, you got to do most of the work on your own, and because we're limited, there's only 2 of us, okay? Right, and that's a great strategy. They said don't just respond, counter petition. However, you only want to counter petition if that's the absolute last thing that you have left. If you can't get their pleadings dismissed, in this particular situation I'm talking about NM, okay? Because we're talking about how do you get out of the court and enforce your current order without going through modification and losing more, or going through, it could be more expensive than an original custody battle. It can be more stressful, it can be more expensive, you can run out of money, you can lose what you've already gained in an original order. So that's what we're talking about right now. So the only reason you'd want to counter petition is if you absolutely needed to get some different things in that final order, make some changes that wouldn't be considered clarifications, right? If you can get a clarification, then you don't ask for a modification, you don't counterfile, you file to have their petition dismissed based on no changed circumstances. You may end up still in a trial, but if you're confident that they don't have changed circumstances and you want to maintain that position, you would have a better chance of winning on appeal if you had all the right elements, and getting things overturned if the judge disagreed with you and they didn't properly actually have changed circumstances that meet the standards in your state. Now that's it. If you guys have been through this, you know changed circumstances can also be very broad. So be a little cautious with this, okay? Kind of playing chess a little bit. You might be trying to get them to settle. So that's my say on this, is just look at different options. Please don't just run to modification. Okay, I've seen those hurt people too many times. Don't blow up what you've already paid for. Let me see if you guys have any questions. And thanks so much for responding to what I was talking about here. Let's see. Do you motion for time limits? Let me see. Do you motion for time limits for trial? My ex filed to modify a 1.5 years ago, and we just completed trial. Too much time for discovery. Okay, so what happens in that is we do have tactics that we use for getting things to move. One of them is not asking for more experts to come in, not asking for studies. And again, this is all going to be dependent on the issues and the facts in your case. So don't just take a piece of this and run with it. Make sure you figure, you get into our membership and you learn the whole process here before you actually make decisions. But I'm going to tell you what some of these are so that you at least know that there are other decisions to be made and other options. And that is, you can get things to speed along by not adding requests that cause delays, because some of those requests create delays because you're dependent on someone else completing something. That's why studies delay trial, right? And that's part of discovery, isn't it? So I don't know if that's what was in yours, Anna, but if you had any kind of requests like that, or requests for the other person to get a psych study, or requests for social studies, requests to have a guardian ad litem brought in, or an amicus. Now you're waiting for them to do all of their investigations, which, by the way, we call unconstitutional as exploratory searches. You need to learn those terms and learn how those protect you, knowing how to object to bringing those parties into, I shouldn't call them parties, but they act like it because they litigate and they advocate and they do all kinds of things. They don't call them parties. But before you bring them in, you need to really understand what's happening here, because most states have no cap on how much they can charge you. A lot of times their fees can be converted as child support. We're talking about guardian ad litems and amicus here, and you can go to jail for those. So if you're broke, or if the process drives you broke, the court's very, very insensitive to that, and you could lose your freedom over it. So ask yourself why you're asking for those things. Why are you asking for someone else to come in and determine what's best for your child? Is it because you think the law requires it? If so, maybe you should be learning how to challenge those statutes that are saying that you're required to have someone else make those decisions in place of you when you are a fit parent, when you have not been proven to pose a danger to your child, you're not in imminent danger. Perhaps you need to ask yourself how to overcome their presumption that if you're in a battle with another parent that your rights are moot, because they might consider your rights are exactly the same as the other parent. So maybe you should ask yourself what would protect you from that presumption. So maybe you need to start learning what presumptions the court's making, right? Those are all a bunch of different topics that we have started covering. Like, I've started breaking out into separate topics. They're all covered in Protecting Family Rights course, which is about 15 hours of lecture. So you can get in there and you will learn all of the foundations that you need for these. What I'm doing is breaking these topics out, and members are seeing those pop up, because I'm trying to simplify and make it easier for you to find those topics, rather than, we want you to listen to the whole course, but we also want you to also be able to manage and address things that are coming up in your situations and cases right now too, while you're learning the foundational arguments. So ask yourself those questions. Ask yourself, why are you asking what you're asking for? What is the outcome you are looking for? And is there another way to achieve that outcome where you are more protected, where your relationship with your child is more protected, where they can't weaponize your child? Those are the things that we provide for you. If that's what you're looking for, then you're in the right place here, and you want to come talk to us, you want to watch our videos, subscribe to our channel so we can help you discuss and work through these issues. I hope you learned something tonight, and I'm going to be doing another live on what is my learned helplessness versus learned optimism. So I hope you turn back in. I did one on Facebook. I'm going to do a shortened version of it this evening here on YouTube right after we finish up here. So again, I'm Sherry Palmer with Fixed Family Courts. So I'm just looking at your questions real quick. You had that for you. Okay, so you had a paid version of Talking Parents, Robert. If you could put comments under this video, let them know that there's a free version and the name of it. They'll probably see your comment. Thank you, that's very, very helpful. I so appreciate you guys when you post things that are related to what I'm talking about, so that parents can have those resources at their fingertips right on videos that are talking about it. So helpful. We all need to work as a team, right? This is a movement protesting the abuse that all of you are facing, which is why you're here today. If your attorneys were doing their jobs, you wouldn't have to be doing this research yourself. But we're learning as a society, we can't be dependent like that. Don't get codependent on your attorney or your courts, because look what happens. These things don't get discovered and you pay 2 times, 3 times, 4 times. I know people that have modified over and over and over again. And before I go, I want to give you guys another example. We had a dad who went to a lawyer, said, I want to enforce my education provision. Had the right idea, had the right language, and what did the attorney do? We need to modify, right? That was their form of enforcement. Hey, if we modify, then you can change the educational clause that's causing you all this trouble, and was resolved, right? Oh no. That parent completely lost their children. Completely. Really, really sad story. It became an absolute mess. It's been thousands and thousands of dollars, over $100,000. And this was not the first time they had been through modification. The last time before that, they didn't initiate it. The other parent did. So you talk about stress and enduring injury and enduring repetitive injury. That's a good way to drag yourself into it, is to get into the wrong type of litigation process. So it's your choice, you guys, what you want to do and how you want to do it. Or at least now you have information where you have choices. So again, thanks for joining me tonight. I hope you'll jump back on with me on the next topic. I'm going to